Hello and welcome back to Diddy on Trial from the BBC World Service YouTube channel with me, Anoushka Mutanda-Dougherty. Subscribe and turn on your push notifications so you never miss a thing, especially as we're going to be in New York bringing you every twist and turn of Diddy's federal trial, which starts in May. Reminder, he's charged with racketeering with conspiracy, sex trafficking and transportation for prostitution. He denies it all. As we build up to the trial over the next month, we'll be bringing you all the latest as the prosecution and defence get ready. Don't forget, you can also send us questions on WhatsApp at +44 330 123 551. That's +44 330 123 551. Today, we're taking a look at court experts, the back and forth over naming victims, the OJ and MJ jury questionnaires, and our elsewhere in the Diddyverse, which is Buzbee, again, the Texan attorney who is filing civil cases for multiple alleged victims of Diddy. Well, he's going up against another high-profile name, the controversial social media figure Andrew Tate. Joining me today to help unpack this all is our resident criminal defense attorney, Shaun Kent. Hi, Shaun.
Hey, how are you doing?
Shaun, I'm looking at this docket every day. They are filing back and forth. They are filing letters back and forth, right? One thing that stood out that I don't think we've spoken on the podcast before about is court experts. At first I read this and I thought it meant people who had expert knowledge of being in court, but it became clearer that it's kind of when they bring people in with a specialty in one of the areas they're discussing, right?
Yes.
Can you bring a court expert in about anything at all, or is there specific areas you have to pick from?
And that's a great question. And there's a standard before you can get in front of a jury. We have a couple of tests. It's from case law. One's called Daubert, D-A-U-B-E-R-T, and one is called Frye, F-R-Y-E. Those are the standards. The judge must, before you can even allow this person to get in front of the jury, they actually have to be an expert. You just can't say I'm an expert in gum chewing. It has to be something that has scientific reliability to the community at whole. After the judge determines it has some level of expertise, the next thing they have to do is what's called a probative versus prejudicial balancing test. The judge has got to make a decision if this is actually going to be probative, helpful, or just prejudicial just to put information in there. For example, you could have a sex position expert. Yes, that might be science, might be expertise, but you just don't want to throw that in front of a jury. And third, and the most important thing, the judge has to make the decision, is it actually going to help the trier of fact? Because really, the funny part about it is, all an expert is somebody who knows more than you know. That's it. So we always make the joke that a fifth grader is an expert on everything in the fourth grade because he knows more than everybody in the fourth grade. And that's the standard. It's weird, but that is the standard.
So immediately the question is, if the defense are bringing their own court experts and the prosecution are bringing their own court experts, who pays them?
The state, the federal government has to pay for the federal government's, and Diddy has to pay for his experts.
So if you're being employed by one side versus employed by another side, isn't there the possibility for expertise to be bought?
The phrase you're looking for is credibility issues. And you've already laid down the first question every prosecutor is going to ask Diddy's experts. How much were you paid to be here? I was given $50,000 to be here. How many times have you ever testified for the United States of America? Never. Isn't it true you only testify for defendants? Yes. So you've been paid. You've been paid by Diddy. If you were saying something against Diddy, would you be testifying right now? Well, no. So really, you're a hired expert. You're hired to give an opinion that helps Diddy, not the other way around. And that happens all the time on experts.
And then Diddy's defense can bat that exact same argument back against any experts the prosecution brings. So what? It becomes like a credibility tennis match? The other thing that I keep seeing is this phrase rebuttal experts that kept popping up in different filings. I think in this case, the prosecution were talking about wanting a sex trafficking expert. So then the defense has a right to bring their own rebuttal sex trafficking expert.
The United States will go first. They put on their entire case. After they put their case on, and they'll say, we believe Mr. Combs has committed sex trafficking, and this is why. They'll stop. Then Diddy's team goes. Diddy will put on an expert. The expert will get on the stand and he'll say, I've been doing this for 30 years. I've worked in law enforcement. I've worked for the federal government before. And everything the United States just said ain't true. That's not sex trafficking, and this is why. And the United States has an opportunity to go right after him and say, well, I am an expert in sex trafficking. I've also been doing this for 30 years. And what Diddy's team just said, that's not true. And then it turns into a battle of the experts.
Who has the time for this? This is extremely time consuming in a trial that already we have, as you said, terabytes of information to get through, discovery material to get through. Back and forth, he said, she said, with experts. That's unnecessary, right? Or that makes the whole process much harder?
The point of an expert is supposed to make the jury understand complicated issues. A good way to talk about it or think about it is, I've had a lot of trials when we're talking about DNA. Okay, DNA is a complicated issue. It's very complicated for people to understand. It's complicated for me to understand. And so when the United States or somebody I'm trying to case with, and as I told you, I had a murder 2 weeks ago about DNA evidence, and we spent a lot of time trying to make it simple for the jury. So we called an expert to be able to say, this is what DNA is, and it's not that complicated, and it doesn't work in this situation. A murder charge is easy. The intentional killing of somebody else with malice aforethought. You know those elements of the offenses. You can't kill somebody. Sex trafficking gets real nebulous and complicated on what is actually sex trafficking. Is it coercion? Is it force? Is it just trying to suggest? Is it? So that's where those experts will be helpful. But as you know, because of this nuanced area, it's going to be going back and forth. There's no, I don't think there's no black letter law for them to make a determination on what's what.
I also just, like you've referenced there, you've referenced DNA and murder and even sex trafficking experts. It feels far more tangible. Sometimes you get experts talking about things or research that they've done on areas that are still evolving and we're still learning things about. I'm thinking here, in the Ghislaine Maxwell case, a false memory expert took the stand and spoke about, you know, traumatic memories sometimes being influenced by media, and it's not a memory isn't something you retrieve, it's something that you sort of recompose, and it can be influenced by many things. But they can make a massive impact. I mean, they can change the course of a trial if they're a particularly compelling expert and if they can go through things in meticulous detail. In the OJ trial, so the massive NFL player where he was accused of murdering his ex-wife and her friend, the expert that came in, Dr. Henry Lee, and spoke about blood spattering patterns and DNA and forensics, he did it in such meticulous detail that a lot of people said they felt that it sort of turned the tides.
A good expert, a great expert, is worth their weight in gold. A person who can testify effectively and make a complicated issue simple is the greatest thing that a jury can have to make a case or make a decision. Like a perfect example, you talked about memory experts. You know, that's a very complicated issue. And I've had experts explain it to the jury this way. They'll look right at the jury and they'll say, you ever get up in the morning and know for a fact that you put your keys on the counter? You're like, yep. And then you go and went to get your keys and your keys are missing. And everything in your heart of hearts have told you specifically your keys were on that counter. You know they were on the counter. And you look all around the house and you're like, somebody's moved my keys. You start yelling at your spouse. Where'd you put my keys? I know they were there. I know where they're there. And then 2 seconds later, you go and you look in the fridge and they're in the refrigerator. And you're like, how in the world did they get there? And in your memory, our memories are so fallible, they create situations. And what you'll see is the jury, everybody on the jury going, yeah, that has happened to me before. And then what ends up happening, they start trusting the expert and then they make it make sense. And for defense, we use that all the time, that we can get a really good expert who can make something that complicated simple, then the jury start to trust him.
Now it's time for Elsewhere in the Diddyverse, and we're talking again about Tony Buzbee. Remember, he's our Texan attorney who has filed claims for multiple alleged victims of P. Diddy. Well, now he's filed another lawsuit against another high-profile defendant, this time controversial social media figure Andrew Tate. If you don't know Andrew Tate, he is a self-proclaimed misogynist with over 10 million followers on X. Buzbee is representing Tate's ex-girlfriend, who has claimed that he physically assaulted her and verbally abused her. In a statement to the BBC, Andrew Tate's attorney, Joseph McBride, dismissed the allegations and called the lawsuit a blatant cash grab. And the spotlight was back on Tony Buzbee, as Mr. McBride also attacked him, calling him a low-life bottom feeder. In a statement to the BBC, Tony Buzbee said he is extremely proud to be representing Brianna Stern. He also posted on Instagram saying, quote, "My message box is overflowing with messages of hate," and he claims people were saying it's her own fault for dating him. Buzbee's caption was accompanied with screenshots of alleged texts from Andrew Tate to Brianna Stern, where he refers to her as Pookie Pumpkin Princess and sends her romantic, seemingly self-composed poems. Andrew Tate's attorney told the BBC these messages were doctored, edited, and falsified. None of it is true. He also added, "We look forward to crushing Mr. Buzbee and his attention-hungry, money-grabbing client in court."
So it's not just court experts where there are updates. There is also some news on the jury front. I saw that they're saying that the jury is going to be sequestered for when they receive their jury questionnaires and they go through and strike people out. So when they're sequestered, they all live in a house together?
They can put them in a hotel, they can pay for it so nobody can get to them, so they're not at home, because one of the big things we don't want is we don't want undue influence to a juror. We don't want people contacting a juror. We don't want Diddy's team, we don't want the prosecutor, we don't want anybody running into them at the grocery store, at the 7-Eleven, and be like, "So what do you think about Diddy?" You want them a free and clear mind, just focused on the evidence, which in 2025 is almost impossible.
Right, so they've got these jury questionnaires that they are going to meet up about on April 11th, meet and confer and come up with the questions, and then they're going to get 600 of them. They're going to be printed and distributed 28th, 29th, 30th of April and get the answers back. Then they've got these 4 lists that they present. Prospective jurors that both sides agree should proceed. Prospective jurors that both sides agree should be excused. And then ones that the defence but not the government want, and ones that the government but not the defence want. How do you then come to sort of a coherent understanding of who's going to be your jurors?
So they're going to send out these questionnaires that both sides and the judge can look at together. The defense would send what they want as potential questions, and the judge will say a lot, "I'm not asking that. I'm not asking that. I'm not putting that on a questionnaire." The prosecution will send questions. "I'm not asking that. I'm not asking that. I'm not asking that." Because you can't ask in the questionnaire, "Do you think Diddy did it?" Because that goes to the penultimate question. But you can ask generic stuff. That's going to eliminate, if there's 600 folks, that alone will eliminate, I'd say, about 150. So now you have about 450 people. Then there is going to be things that are called peremptory challenges that we have talked about before, that either side, they get a certain number of challenges that they said, "I don't want that guy." Why? Because he's got a Kanye West shirt on. "I don't want that guy because he's got a funny hat." As long as it's a race-neutral reason, the defense or the prosecution can eliminate anybody.
Did you say race neutral?
It has to be race neutral.
But not gender neutral?
What? That is such a bigger topic, but what ends up happening, and I'll give you a very quick view. You're exactly right. It should be gender neutral. But what we do, our Supreme Court has specifically said there's certain groups of individuals who have been historically treated poorly, and they go in order. So they first start with race neutral, then they start with gender neutral, and it has different levels of scrutiny. So you're right, it's supposed to be a gender neutral reason, but the court doesn't look at that the same way. Because the defense could say, "Mr. Kent, why'd you exclude that woman?" Well, because she's a woman and this is a case against Diddy and we want to try to keep as many women off the trial as possible. "Mr. Kent, did you put any other people who fit that category in the jury?" "No, Your Honor, our strategy is to get rid of as many women as possible on this jury." You can almost get away with that. You can't get away with, "Well, because he's black." You have to have a neutral reason dedicated to your case for eliminating somebody.
Once they've got them up there, they've gone through the lists and they've got the jurors there for the peremptory strikes, which is happening on May 9th.
Yep.
And they say, "I don't want you and I don't want you." What is the basis for not... Are they researching these people? Are they doing background research, or they I don't like their vibe?
The funny part about it is sometimes I've done that. Like, I've picked a jury before and everything looks great on a piece of paper, and then you see the juror stand up and you look at you. I'm like, "I don't know what it is, but I don't like that guy. Strike." And sometimes the judge is like, "Mr. Kent, why did you," like, if the government challenges, because there's been situations like Mr. Kent eliminated nothing but white males over, why were you eliminating these folks? And I have to give my neutral reasons. That dude was looking at me angry and I don't like him. You do things like that. But for the most part in these situations, I think they've got teams who are going to be scouring through these lists. They're going to be looking at those questionnaires. seeing how they answer questions. The problem though with questionnaires is nobody's going to write on a questionnaire, I hate Diddy, I'm a racist, I want him to spend the rest of his life in prison. That would be easy, but they're not going to answer that way.
I was looking at the Michael Jackson jury questionnaires for the involuntary manslaughter. I think it's Dr. Conrad Murray, if I remember correctly.
You got it, Conrad, Dr. Conrad. Connie.
Gosh, I think, what was that, 2009?
Mm-hmm.
I remember, I was 9. I remember.
Yeah, that makes me feel so much better about my life. There was zero reason to throw that in there. Thank you.
But I have a really clear memory of it. Not least then because Nicki Minaj came and did a verse saying like, MJ's doctor, they're trying to kill me, which was just absolutely wild. But I've never looked at how they would have picked the jury for that because obviously Michael was all over the press for good reasons, for bad reasons. I mean, he was arguably the most famous man on earth. Some of the questions on that questionnaire are, have you ever thought about Michael Jackson? Have you ever, what is your opinion of the Jackson 5 and then both Michael Jackson? Would you, if you said, yeah, you know, I really like some of the early Jackson 5 stuff, would they eliminate you or keep you? What's the point of those questions? Because of course you've thought about Michael Jackson. He was everywhere.
Every defense has different strategies. Every prosecution has different strategies. And what we're trying to do is, it's like a divided attention test. You understand? You can't, because if you ask a very specific question, you know the answer you're going to get. Do you hate Michael Jackson? No one's going to answer that question. You understand? Like no one's going to answer that specifically, so you're not getting an answer. Like a question I may ask on the Diddy case is, are you on TikTok? You know, and that puts something in my mind. That's a juror that I'm not going to potentially want. Are you on social media at all? Someone says, no, I'm not on social media whatsoever. So if I'm not on social media at all, that might be somebody, I want that person. That's somebody I potentially want for my trial. So those are, you want to ask very generic questions. What year were you born? Like you might want to know if, you know, did you like Bad Boy Entertainment? There's all types of little things you're trying to figure out, but without letting the jury know what you're trying to get to. Everyone thinks it's a science. It's a big gamble too. And it's a guessing game. And it is, the dirty little secret in the legal system is it's a stereotyping system.
Wow.
When you're all in closed doors, we all say the same things. Like defense attorneys want black and minorities on juries. It's like, why do we want black folks and minorities? We find them to be more likely to listen, more sensitive, have gone through more oppression, more likely to find not guilty. Prosecutors try to avoid black folks. They try to avoid minorities for the same reason. And I wish it wasn't that way, but you know, that's the way it works sometimes.
Well, this is obviously going to be a big thing, the picking of the jury and the makeup of the jury. There was questions about whether their identity would be kept a secret. They would be anonymized and referred to only by a number. Is that sort of to protect them from being, you know, press and book deals and all these people trying to go after them to find out what's going on behind closed doors?
Yeah, and that happens a lot. You know, the anonymity of a jury should happen in almost every trial. Like, you know, if you've ever watched any trial, you never see the jury's faces on the video footage. Like if there's ever cameras allowed in a trial, we don't let our juries be be shown because you don't want them intimidated. You don't want people calling them. You don't want people contacting them. But the judge tells them every day, you cannot discuss this case. You cannot talk to this case. You can't talk to your family. You can't talk to your friends. You can't talk to media. The second the case is over, the judge releases it. He's like, y'all talk to whoever you want to.
Yes, because when I was looking at the 1995 OJ questionnaire for his trial, it said, what do you think about a juror writing a book about his or her experience on a case? That's not illegal for them to write a book or do interviews.
And that's also something you have to be careful about. There's a lot of times there are people out there who want to get on high profile cases because they know they can make money on it down the road. There's nothing to stop somebody to talking about how they've dealt, what they've gone with.
Could you eliminate somebody from being a juror if they had suffered sexual assault?
Absolutely. Like that would be one of those situations you would go to the judge and say, I don't want to use one of my peremptory strikes. I don't think this person can be fair and unbiased based upon their history. I'm asking the court to remove this person for what's called cause. For cause, get this person off of the jury because there's no way they could be fair and impartial. Because remember, I told you, the only question that the judge asks is, ma'am, can you be fair and impartial? And I've had this situation. Ma'am, you have just mentioned that you are a victim of a crime. Do you think you can be fair and impartial? And she says, yes, I can. The whole time crying. And then, of course, like, Judge, with all due respect. And he's like, I understand, Mr. Kent, ma'am, we're going to excuse you for cause. Even though she's answered the question right, sometimes you have to watch the body language because you see sometimes people cannot be fair and impartial.
That's so interesting what's going to happen there. I just feel like we're going to see it for this is going to set a precedent for these kind of cases.
It's going to be different than anything we've ever seen. That's why people are so interested in it. And I don't think it's the tip of the iceberg when they see what's really going to happen.
There's all of this stuff about the jury, which is fascinating. There are some other things that have been filed, which I was like, oh, okay. This reference to not using Rule 412, 412, not using people's previous sexual history or previous or sexual proclivities as part of the trial. That to me read as a really good thing, because it would be very uncomfortable for somebody's entire sexual history to come with them onto the stand, particularly people who may have been victimized.
It is. Diddy's team filed and said, Judge, we are not going to be getting into this, which I think is hilarious. It's sort of like, you're not getting into something that the court wouldn't allow you to get into anyway. So it's sort of like, we're not going to do this. And I can see the judge saying, well, I wasn't going to let your tail do it anyway, so why are you telling me that? But because our rules are very specific when it comes to victims of sexual assault, we don't want individuals to be victimized again, okay? And so what we say under the rules is if a person takes the stand and say, I have been victimized, generally, you are not allowed to get into their past sexual history, the things they've done with other people, because it's irrelevant and it's embarrassing and it's hard. And then the underlying reason on why we do that is we want victims to come forward of sexual assault. You don't want to create a system where they're scared to come forward because they're going to talk about the nasty stuff they did at a kegger in 1994 in college. You don't want that stuff to come in because it's like, oh my God, I don't want my mom to hear this. I don't want this to hear about it. And it's embarrassing.
They've filed, the defense said we're not going to use Rule 412, and the prosecution said we're not going to use it either. Did they say that because the defense said it, or is it just good practice? Or
well, we're not going to get into it either, but why would the prosecutor want to get into the victim's sexual history with other individuals? So they filed it just because it's good practice.
But they can't get into Diddy's sexual history as well, right? They can only speak specifically about the people who are involved in this trial.
There's a rule right next to 412 that's called 413. And 413 and 413 basically allows you to get into Diddy's sexual history if somebody has made a claim about him. It is the nuanced, unfair thing about our system. So everything that I just told you that we don't want to do to victims, we allow in the federal system against defendants. If somebody has claimed without proof, believe it or not, there doesn't have to be a conviction. But if somebody says, he sexually assaulted me, I want to get into it, the government's allowed to get into that.
It doesn't look balanced. I mean,
it's not in this federal system. I mean, it's even more crazy when you look at the two rules right next. 412, 14, they're right next to each other. We don't want to re-victimize victims, but you're on trial for your life, and I'm not trying to be disrespectful, but you're on trial for your life. We're going to bring in other acts that are completely unrelated.
So another thing that's up for discussion is pseudonyms for the victims. So the victims not knowing who they are. Prosecution call them victims. We've spoken before that they're actually technically alleged witnesses to a crime. And the defense have said we do not want them to use pseudonyms. But Diddy would be aware of who these people are. So why do they care whether we as the press and the public know who they are?
And from the beginning, the first thing we talked about is when you go to the stand, your credibility goes with you. And if anybody who's out there has ever testified, testifying is the most nervous thing you can do. And a lot of times what people want to do is if their anonymity is not protected, sometimes people say, I'm not testifying. I'm not putting my name out there. I don't want to be associated with this trial. And so what prosecutors try to do is say, we will limit your testimony. Nobody will know who you are. It'll just be initials because you're trying to convince this person to testify. A lot of these women, men, so forth, don't want their name associated with this case. And I bet you there's a bunch of them out there who aren't telling their family and friends, Yeah, I was in the middle of one of those freak off parties. I flew out there from Colorado, because it still has a stigma to it. And so if I'm the defense, I want their full names, I want their full testimony, I want them on the stand. If they're going to confront anybody, and we have a confrontation clause, if you confront somebody, show yourself. What's that? Show yourself. Show yourself. You must show who you are so that I can properly cross-examine you.
We are edging extremely close to the beginning of the trial. So I do feel like, because they have said, if we do have pseudonyms for these victims, there are a lot of these victims' witnesses, there are a lot of logistical considerations around that.
And don't forget the subtlety, the very subtlety of the jury hearing the prosecutor saying, we are only referring to you by your initials because we don't want your name. That's telling the jury, we believe them because we're only letting you know, go by your initials. You understand the subtlety of saying, we're only going to use you by your initials because we're worried and we're scared and we're fearful for you. Trials are supposed to be fair. And that little subtlety of being able to refer to his initials, it's even, we have made objections, and I know other defense attorneys have made objections that you're not allowed to be referred to as a victim. Because it's a subtlety. You are you're not a victim of anything until there is a conviction, technically. And so there's an objection that we don't want this person to be called a victim at this point in time because it's a subtlety of not giving Diddy a fair trial.
Shaun, thank you so much for coming and explaining this.
Thank you so much for having me. It's starting to get more interesting. It's starting to cook, and it's going to get, every week's going to get a little more fascinating.
That's it for this episode of Diddy on Trial from the BBC World Service YouTube channel with me, Anoushka Mutanda-Dougherty. Make sure you subscribe so you never miss a thing, and keep sending us your questions. You can get us on WhatsApp at +44 330 123 551. That's +44 330 123 551.